Hello and welcome to Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson and I own Covert Ops Jury Investigations. What do we do? I'm glad you ask. We are hired by convicted persons to look for the biased jurors who lied during jury selection and denied them a fair trial. In the last show, I explained the timeline of my husband's trial to being sentenced to life without parole. In this show, I'm going to pick it up there and explain what happened next. To do that, I've invited my special guest, appellate attorney Steve Gosney, to talk about the part he played in Martin's appeal. As I stated before, this subject matter is disturbing, and while we will not go into graphic detail, this show is for adults only. So help me welcome attorney Steve Gosney. All right. Welcome, Steve. So good to see you again.
Good to see you. It's my buddy MaryRose and of
Yeah,
Covert Jury Ops, and one of my great clients that I've had the honor of representing. Actually, your husband, but
that's true.
you know, but we are
You,
joined together as one.
yes, you got stuck with me too.
No, it's an honor. It's an honor to know you and Marty.
Oh, well, it's a privilege to know you and an honor to call you our friend. I
Thank
tell
you.
people all the time that say I had a public defender. I said, you know what? You won't find anybody that'll work harder for you than a public defender. And I said, and they don't get the thanks that they deserve. And you certainly, I know you think you played a little tiny part, but you played no, you played a huge role in laying the foundation for Martin to eventually be able to come home because you put the seed of doubt in our judge's mind and
Well,
heart.
we can go through the story about, and I'll just leave it to others to decide how much I had to do with it. But we'll that's it's better just to tell the story, and whatever credit, I'm just public defenders, they fight the cause, they serve where they do because they believe in cases and they believe in the justice system. At least the good ones do, right? they
Right.
they do it because not for money or not for compensation. They do it because there's a cause here. What's that cause? That's vindicating the rights of their clients, even the guilty ones. And occasionally you'll come across somebody who's actually innocent and wrongfully charged, in which case all stops are brought out, right? And
Yeah, yeah.
let's so that brings us to your case. So let's talk.
Yes, yes. Well, last week I talked about up to well, from trial to sentencing. So we left off where Martin had been sentenced to life without parole, and I want to pick up here where you step in and you help maybe with the how you got the case and some of the backstory that I probably don't even know.
Well, actually, yeah, that's interesting because we've talked before about Marty's case, and you've been on my channel. I've written about your case,
Mhm.
and but let's talk about from a public defender. I worked at the public defender's appellate office, and your case was randomly assigned to my desk. God works in mysterious ways, right?
Yes, he does.
And it's just it comes in as a file, as an appeal. Another life in prison guy who's filed an appeal, which of course, as soon as they sentence somebody to life in prison without parole, they say, and by the way, you have a right to a public defender for your appeal. Do you want to appeal? And of course, every lifer says, yes, I want to appeal, right? So many cases you would get in the public defender's office would be people got sentenced to life. There may be no issues. In about half my cases, there wouldn't be an issue. And that's what we call an Anders brief. And then, sometimes there's minor issues, in which case I would brief it. And then sometimes you'd get a case that would jump out at you as being one of injustice, and there's a problem. There's something wrong. And yours was, I would say, in that last category, or I'd say Marty's was. It came in, and I was reading it, and I was like, there's a lot of things wrong with this case. There's a lot of things wrong with this case. And so that's the way. So, and what I do, and of course, when that comes in, I'm like, I've got to find a way to brief this, even if I know, I've been an experienced attorney, I've done almost 500 criminal appeals. Even when I know that it's not going to go anywhere,
Right.
I know it's not going to succeed. When somebody's actually innocent, there's somebody who has been wrong. I'm going to find a way to brief that case and do the best I can. And so, of course, and I will never forget, and we talk about this, we've talked about this before,
Yeah.
never forget the first call from MaryRose Peterson, right? And I get this call, and well, why don't you tell it? Because I've told it the story. You tell me what your perspective is, because I've heard myself talk. What was your first impression of our encounter?
Okay, yes, I do remember that first phone call. I didn't know anything about the law or appeals. Everyone kept saying, oh, well, they will appeal it. And I said, okay. And then I don't even recall how I found out that you were the lawyer on the case, but I did get your number and called. And I remember just asking some questions. And then I recall asking, are you going to write a brief? Because that's what I was told to ask. Are you going to write an initial brief about this? And you said,
Of course. Well, I said absolutely. Well, the thing that jumps out about that was I said that because I tell all of my, people call in, and I would always say to clients and families of clients, I would give them the whole what I call the 3850 speech. In Florida, we have a rule 3850, right? And that was that, because you were saying you had all these charts and you had all these reasons and all this stuff, and it was like too
I
complicated,
I
too
showed
complicated.
that I showed that last week.
And I'm like, too much. I said, just get to the point, because judges, nobody's going to read that.
No.
And you're like, well, how can I help? How can I help? And I'm like, well, there's really nothing you can do to help me. It's all that when an appeal comes in, the record is fixed. It is what it is, and you can't add or detract from it. It is what it is. But I said, but what you can do is you can start working on your 3850. And you're like,
Yeah.
what's a 3850? I said,
Yeah.
well, I said, that's a process like, let's assume that this appeal does not succeed, which is most of the appeals, which we have a statistic on that. And the statistic is 0.6%. That's six out of 1,000 appeals, criminal appeals, succeed. So very low percentage. So I said, what you need to do is focus on this post appellate issue that I'm not going to help you with, and lawyers aren't going to help with. And it's what you were kind of doing or you were thinking.
Mhm.
And I will say, I give that speech to people. And what makes you stand out is you actually listened.
Well, as you were talking, I was Googling 3850 Florida, trying to get some. It's like when I talked with the state attorney's office and they were telling me things, I'm Googling all these legal phrases that I didn't know anything about. So yes, I was learning, and I actually got kind of excited because it talked about that's where you would say that your trial attorney was ineffective. And I didn't know much about lawyering at that point, and I had only been in court with Martin for his trial my whole life. So, well, there was that one speeding ticket that I had to go to court for, but we won't talk about that.
Oh.
Yeah. So I was kind of excited about throwing the attorney under the bus, so to speak, because I felt like there were a lot of things that she either did ineffectively or that didn't do that maybe could have done at
Right.
that
Well,
point.
it's always easy to second guess when there's a
Sure.
conviction, right? And
Right.
and those are very difficult choices that in a trial attorney. And I'm a board certified criminal trial lawyer, so I have a unique perspective from an appellate perspective. I have a lot of sympathy for trial lawyers because they have
Yeah.
to make a lot of hard calls. And of
Right.
course, if somebody's convicted, every call they made is wrong and subject to questioning, right?
Right.
And courts are very attuned to that. And so they will discount criminal appeals because it's like, everybody appeals. But the thing that you latched onto and you ran with, and I would almost say that that first conversation was probably the inception of jury investigations and everything that you've done since, because
Yep.
you took that ball, and let's kind of jumping to the end. We all know the end. We've seen Marty free.
Yeah.
Your husband is life in prison without parole, is freed based on the 3850, which that initial conversation that I told you, you took the ball and ran with it. And I will take very little credit for that. I mean, you put a lot of work and time and effort into that process. While I was doing my thing in appeals, you were
Yeah.
doing your thing in the 3850 and prepping it. And
Yeah.
we were simpatico in that way. So
Right.
so I'd say that first conversation, our first time we met, was the basis for everything you've done since then.
Yes. Well, you gave me a lot of foundation foundational material, because when you argued it, and we'll get to that more, but when you argued it, you talked about all of the things that went horribly wrong with the case, basically. And that is what put the idea in my head to, okay, then what else went wrong?
Well, you found the key to the jail cell. I'm looking at it from an appellate, so I couldn't do what you did post appeal. Okay, but let's just talk the big picture. I actually did two appeals for Marty, right?
You did.
Because we actually, and from appellate standpoint, we won the first appeal. And
Yes.
what an appellate win means is I get another shot at the judge, right? So,
Yeah.
and your case was one that I took very personally because I felt Marty was actually innocent and had been wrongly convicted. And I did not trust any other attorney to argue it because it was a very complex case. There was a lot of evidence. There was a lot of things that needed to be explained. Somebody really needed to master the record in order to argue it before that judge. Right. And so I didn't trust it. So I asked for special permission from the elected public defender so that I could go over to Brooksville to argue on behalf of Marty to that judge. And I think I did my best. I got to say, I really tried. I did not.
You put on a performance of a lifetime. I sat there trying not to cry the whole time. I didn't know whether to clap or cry or laugh at times. It was beautiful. You put into words everything that been trying to say, but no one was paying attention except you. You finally somebody was paying attention and took that and said, "You're right, MaryRose. This is a horrible travesty of justice, and this needs to be corrected."
Well, and what I think I brought to the table there was, first of all, editing out a lot of all the detail that
All the noise.
that you had created. And there was a lot of detail in this case. There was a lot of reason taken out and focusing on the most powerful things, number one. Number two is enunciating them in a way that was clear and direct and within a legal framework. Right. And third, I would say that presenting it professionally but forcefully, and this is something that people that are dealing with, there's a lot of emotion involved here. Yeah. It's such high stakes, and it's very easy to get overwhelmed by that and to lose your objectivity and to lose your professionalism. And so you can be strident and you can be tough and you can be a zealous advocate, but also be professional and respectful. And because once you lose the white hat, once you put that black hat on, then you're giving the judge a reason to discount you and to rule against you. And you should never let the judge do that. So instead, what you do is you come in, you argue forcefully and factually, but you don't do it disrespectfully, you don't do it unprofessionally. So you retain that white hat, and then it puts the burden on that judge. And I think I gotta say, I know we didn't win that hearing, but I think we put a seed of doubt in his head. I mean, what was your impression of that hearing?
That's exactly it. You made him think about it. And fast forwarding years later, he actually said in court, there are only two people, and I'm not quoting directly, I may have a word or two off, but I'll paraphrase. He said, Judge Merritt said something to the effect, there are only two people that know what really went on, if anything. And as for me, I have my doubts.
Right. And that's called reasonable doubt. Now, and it's interesting because, and that's the key. The key to this case is there was so much reasonable doubt. And I've represented, I was a public defender. I've represented very bad dudes who did very bad things. And my job was still to represent them. Right. But I know reasonable doubt when I see it. And there was all kinds of reasons. It doesn't, the allegations against your husband did not fit my experience for the way those things happen. And it didn't fit common sense. And we argued very passionately. And I think that I felt that was a very good hearing. I thought the judge was paying attention, and I never gave him the excuse to dislike me or to hate me or to say I was being unprofessional. So he had to consider our arguments, and that those resonant effects. But let's talk a little bit about the institutional pressures on judges like this, because and this is something that most non-lawyers, people that aren't this closely and intimately involved, are not aware of. And that is that if the system was to admit that there are innocent people in prison, that would be very hard. That's not something that people want to admit. They want to think that everybody that's in prison did something wrong. We just don't know what it is, right?
Right.
And if you start down in that, if you say, you know what, sometimes innocent people are convicted, even in the best system, it is imperfect. It's hard for people that are involved in the system to admit that fact.
Right.
Now, and I think one of the things you said to me once, and I always, and it's something that's echoed through a lot of my clients in the criminal sphere, was, well, I know you're going to do a good job because I have faith in the system. And I always said,
Yeah.
I have faith in God.
Right.
I do not have faith in the system.
No.
It's a human system. It's flawed. It's imperfect, and innocent people get convicted. Now, I'm not saying that's widespread,
Right.
but it happens. And I've seen it happen too much. And a lot of it comes from that monotone, blinders on, I believe in the system attitude on the part of the prosecutors and the judges and the jurors and everybody else who think, oh, well, if they've been charged, it's got to be convicted. The police don't make mistakes. Judges don't make mistakes. Prosecutors don't make mistakes. We all make mistakes. We're human beings. And that is injected into every system.
Right. I was a foreperson once, and we sat there all week listening to the state present all witness after witness after witness. The two defendants didn't say anything. They exercised their right to remain silent. And I sat there the whole week thinking, if you didn't do it, then this just seems like a ridiculous waste of not only these law enforcement officers' time who have spent 2 years preparing this case, and these prosecutors who have worked on this case for probably a year, and all of these witnesses that come in, and the judge that's there, and the jury, we're sitting here apart from work. And I just thought, if you're not guilty, how am I even to believe that you're not guilty? Because to believe that you didn't do this and that you truly are innocent means that I have to believe all of those people that have spent the whole week coming in here and giving testimony. I have to believe that they're all telling lies, or they're just horribly misinformed, in order to believe that you are actually innocent.
Well, and that goes to the law review article that came out of I've written multiple law review articles, and one of them came directly out of your case and actually came out of the brief. One of the points in the merit brief that I raised in the first merit brief and the second appeal, I raised it on both of them. And that is that, and people have trouble understanding this, but your case involved one accuser and no other evidence. One accuser saying something. And in fact, that accuser said something that was accusatory, but they also contradicted themselves on major elements of the case. Yes. Now, I had to go back to Wigmore and evidence. Florida uses Earhart on evidence, and he has a book on it, right? And so he's FSU and he's popular. But Wigmore is the authority. He has like 15 volumes, and he has pages and pages. So I hit the library. I had to go and pull the old dusty tomes out of the law library to pull out Wigmore and evidence. In which case, to directly address this point, and my point is, and this is my personal issue that I raised in your case, it was not successful, but I believe in it. Mm-hmm. That is that if you have a one witness case without corroborating evidence, mm-hmm. and that witness contradicts themselves on an element of the case, that should be, by definition, reasonable doubt. Yes. Because you have somebody under oath swearing to tell the truth, and they say contradictory things on an element of the case, and there's no corroborating evidence, which is exactly what your case was. Yes. But that case went to the jury and was convicted and resulted in life in prison for Marty.
Right.
And this is a major flaw. Now, there used to be something in Florida called, in a circumstantial evidence case. Now, this was not a circumstantial, this was a direct evidence case, because testimony is direct evidence. But in a circumstantial evidence case, if there's a reasonable hypothesis of innocence, mm-hmm. then that means that's reasonable doubt. But Florida's done away with that protection too. So wow. there's very little protections against false accusations, circumstantial evidence cases, and this is a big problem. And I understand that the desire to, but the chances of getting out on appeal are 0.6%. So it is way the media likes to pretend like it's this huge problem. It's not. The problem is the other way.
Right. Well, and in Martin's case, there was no corroborating evidence until right before trial. Suddenly, they had his son saying he couldn't find, looked for Martin and couldn't find him. And he saw Martin coming out of her room. And it was like, wait a minute, you've been deposed and your testimony said you never heard anything, you never saw anything. Even his mother and everyone involved in the case said he didn't know anything, never knew anything about it. So there was coercion, in my opinion, in order to get a corroborating testimony at trial. And even then, his son had a very hard time getting the words out. So there, and then even the outcry witness, I know they say, and you can correct me if I'm wrong, but I've been told that in sexual accusations, that there has to be some sort of outcry witness that the person first outcried to. Now, in order to go to trial, is that true or no?
No, I don't think so. No,
Okay,
you just need,
when they're young, when they're underage,
well,
do they have to have an outcry?
there's called child hearsay, which are exceptions, allows statements of children to go to come in, even though it's hearsay. If
Mhm.
they spoke it to some adult or some person, that can come in over hearsay objections. That might be what you're talking about.
That's
But
probably,
but here's the problem with sex offenses, and those are, I gotta say, I've represented some pretty bad sex offenders in my time. All right.
I'm sure.
First of all, I'll say that they're very difficult to represent, and Marty does not fit any of those boxes. It's I've dealt with the real deal, right? And so I know when I've dealt with the real deal, I know when I'm dealing with somebody that doesn't fit that that box. But the problem with accusations of sex offenses generally, it's very difficult. But it's that talking in a public way, in any kind of public forum about sex, is uncomfortable
Yes.
because it's a very private, personal, not something we like to talk about in a public place.
Right.
And so here we're talking about the most formal of environments, a courtroom where there's a judge and everybody's uptight and tied up and very formal. And all of a sudden you start slinging around sex words.
Right.
And it's cringy, it's uncomfortable. It's like, ugh, this is
Yeah.
nasty.
Yeah.
And then the people look over at the defense table and they're and this is it's not the way. So it just by its very nature, it's hard
Right.
to talk about, and it results in this predilection to believe it, this predilection to think, oh, this accused person must have done it. And I know that there's this Me Too movement. I mean, I've seen my share of false accusations, and women are human, men are human, we're all human beings. They can lie, they can make up false memories. This is another part of it. Like we talk
Right.
about Cherokee, people can talk themselves right into things. And in fact, in your case, and I know that you've given me waiver and Marty has given me waiver to talk about your case, right? Let's get that clear.
Yes. Yes.
Um, I always wondered if the accuser here in this case actually believed what she was saying, because what happened was she had a friend who was gay, a gay male friend and they were watching hardcore pornography together on the computer.
Right.
And this friend had a beef, let's say, with somebody, like an uncle or a relative, and said, oh, I got back at him by accusing him of a sex offense and passed a note, and it resolved my problem. And this accuser, in your case, did the same thing. But the imagination, the mind is strange, especially young people. But our brains create memories, and whether or not the memories from the pornography were translated into some memory, I don't know. Or perhaps it might have just been malicious, it might have been reconstructed memory, it might have been a lot of things, but it was so wildly inconsistent and unbelievable, I guess is the word.
Yes.
that I'm like, this didn't happen. This didn't happen
Right.
this way. It couldn't have happened this way.
No.
And there were so many little details that then this was the major lie that was, or the major thing that was contradictory was, well, it happened once or twice.
Yeah.
And then it says, well, was it once or twice or pretty much every day? You said, oh yeah, pretty much. It happened pretty much every day over multiple years. Well, which one is it? Is it every day over multiple years, or is it once or twice?
Yeah.
And she said, it's pretty much the same thing.
Yeah. I said that in the last show. I said at that point, I was like, okay, where are we going for dinner? Because we're done here. And
But
I had to try not to laugh. It was like,
but
what?
it's but it's the but it's the but this is the thing, is that all of these issues we've talked about, the formality of the courtroom and opposed to sex talk, the oh, they must have done something, the accusations. And there's also the, if I'm a juror, I'm like, well, could have happened, maybe it didn't, but you know what, if it I don't want this person getting out on purpose on somebody else, so the safe thing to do is convict.
Right.
And they don't understand that when they convict, that's life in prison.
No, they have no idea. They're not
Yeah,
allowed to
because they're
know
not
that.
told the sentence.
No, they're not allowed told that. And I think a lot of jurors who have an agenda do say, let's err on the side of caution, you
Right.
know. And
And that's a
counsel,
reasonable thing to do in
sure,
life, but
sure.
within the system, it's not what you're supposed to do, because
No.
there's so much reasonable doubt in this case.
Well, and they weren't even in the deliberation room for a half hour. It was
Well,
like
of
20
course,
minutes.
well, you found the key, which was
Yes.
the biased juror.
Yes.
And we made these arguments to the court, and the court rejected them.
Yeah.
So, I mean, don't believe that the court is your friend. The court is
Oh no,
predisposed to guilt.
they are. And once the jury has decided, it's done. Court's adjourned. And that's where I find the stamina and the drive to keep doing what we're doing, because I know after 107 cases that there was a biased juror on every jury. And the thing about it is, they haven't even got to trial. So it's not like they even know very much about the case. They know enough to know what it's about. And that's where I think they decide, I want to be in on this for a variety of reasons that we've discussed before. But, in Martin's case, it just, none of it made any sense. And the more that we dug in, the less it made sense.
But see, but you came in it. I think that you and Marty both came in with belief that we believe in the system. And this is the thing that I know. I mean, like I said, I have faith, and my faith is placed in God, and that's idolatry to put your faith in any other place. But I
Amen.
and I and Marty turned down probation
Mhm.
the
Mhm.
day before trial,
Yeah.
but he did so because he believed in the system.
Yeah.
and
Well,
and that's a hard thing, because he's like, I'm actually innocent, and surely this jury is going to see
right,
these major contradictions in
right.
this case.
Well, that's it. He knew the whole backstory. He knew how his wife wouldn't even file for divorce after all this came out. He knew that she wouldn't take their daughter for a medical exam, had to be forced to do that by CBT. He knew that she came at him a few months later and said, well, this will all go away and we'll leave your house for $25,000. And he said no. And she said, all right, 10,000. So, I mean, he knew all of this backstory. He knew that he didn't do it. He knew that they were lying. They were literally making it up as they go, which we'll talk about next week when we get into more of that. But he knew, and he felt that as soon as they take the stand and start to all the contradictions and all the nonsense, and thought for sure that his attorney was going to present the medical evidence that showed she was still a virgin and there were no signs or no indications of trauma, which if you were being raped every day for 5 years, you
Right.
would you would be,
There'd be some indication. Well,
between the ages of 10 and 15, you'd be messed up.
can I also
Gross, but
add one more thing? And I know that our time's limited, and I always love being around you and listening to you. And this is one of the reasons, because this is talking about lawyers and public defenders and relationships and this sort of thing. I mean, there's not many former clients that I keep in contact with. You're one of the few. But one thing, that even after the second appeal, and the second appeal didn't go our way, you never blamed me. You never pointed the
Oh,
finger at
no.
me. And I think I didn't ever commit to you that any success. I said, I will do
No.
my best. I will do my best. That was my commitment.
Yes.
And I think I always did my best for you. And I would always make that commitment. I'd say, I'll do my best. And I did. But you also, even after that second one, which was very hard on me, I'll say it was
It
because
was.
it was hard on me.
It was
It,
hard.
and you were always positive, and you were always, I know that you've done your best, and you were always supportive of me because I was your advocate. And
Mhm.
I will tell you that is rare. I know that's sort of an odd thing to say, but so many clients, when the ultimately the event is, they turn on you just like a second. It's like,
Yeah.
oh, you're the problem.
Right.
I'm a part of a system, a flawed system, and I'm going to do my best. And if I'm doing my best for you, that's all I can do.
Right.
I don't have the keys. If I did something better or something, I'm not. And so I think that's a good lesson too, is that try to treat your advocates, the people that are for you, treat them with the respect and the support that they can best you can possibly, win friends with honey. And you
Yeah.
were not that, I mean, that didn't affect how I treated anybody,
I know.
but I will say it was notable in your case. I have a few clients that have done that, but you were one of them, and I really appreciate that.
Thank you, Steve. You've been life-changing and you continue to help. And I know all of the things that you said today will be of help to someone that's listening. So thank you. Thanks for being my friend. Thanks for being Martin's friend. Thanks for fighting when no one would. Thanks for being a public defender that truly defends not only the law, but your clients, whether they deserve it or not. I love that about you, that you don't judge. You leave that to
Well,
God.
yeah, it's up to God to judge, but also always do your best. Always be fidelity to the truth and to your ethics, because the big problem we see is that people like to do these gut reaction changes, like the prosecutors. I'm a big critic of a lot of prosecutors. Think, well, they're guilty anyway, so I'm going to cheat on here and cheat on there. That is a betrayal of a prosecutor's duty to the law. Because the accused is also a citizen of Florida. And so you owe a duty of fair play to that citizen of Florida. And this is that people need to stay in their roles. A judge is not a prosecutor. A judge should be a judge. A
Mm.
prosecutor needs to be fair to all parties. A defense attorney needs to advocate. We need to stay in our lanes and know and trust in the process enough to let the people do the work, the process. The problem is everybody wants to sneak over here and get to the end result that they think that they want to boost their egos. Put your ego aside and do your best and do what's right. Do what's right no matter what the cost. And you do it in your role and do it fairly and honorably and ethically. And that's what you should do. And that would make the world a much better place, because there's way too much not that within
Yeah,
the system and within our society and the world as at large.
right. Amen. Speak the truth. Amen. Thank you again. It's been a pleasure. We'll talk soon.
God bless.
Thank you, everyone, for watching. In the next episode, I'm going to explain how we investigated the jury and expose the lies that we uncovered by the foreperson. Those lies were the key to unlocking Martin's prison cell. So be sure to tune in next time for another episode of Jurors in Disguise. Until then, if you know of someone who's been convicted by a jury and needs our help, you will find our contact information in the description below. Again, we thank you for watching, and remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.